Good morning, Your Honors, and may it please the Court. My name is Denise Rockowich. I represent the appellant defendants, Fullerton Police Corporal Crabtree, Corporal McShane, and Sergeant McCaskill. I'd like to reserve 5 minutes for rebuttal. This is a case arising from a district court's denial of qualified immunity. So to begin, I really want to emphasize the importance of that doctrine because I think that got missed in the district court's opinion. Police officers such as the appellants here are presumed to be protected by qualified immunity. To overcome that presumption, the contours of the right in question must be such that they're sufficiently clear that every reasonable official would have understood that what he was doing violated that right. So the standard is not whether the established law supported an officer's actions, rather whether the established law prohibited the officer's conduct. The Supreme Court has repeatedly stressed the importance of qualified immunity and has repeatedly instructed the lower courts on that second prong that the established law should not be defined at a high level of generality. The Supreme Court case in White v. Pauley illustrated that concept in terms of use of force cases, with the court explaining while Tennessee Garner and Graham v. Connor lay out the principles of excessive force, they are merely general statements of the law that are not capable of giving fair and clear warning, such as to clearly establish the law on particular uses of force.
What about the entry into the home without a warrant?
Excuse me, what's that?
What about entry into the home without a warrant? Surely that is clearly established, and every officer knows you can't enter a home without a warrant unless there's a valid exception, right?
Absolutely. And that's part of the problem here, is that the district court's opinion on that second prong stated that grand theory of the emergency exception, saying there's no community caretaking exception to the Fourth Amendment warrant requirement. We wholeheartedly agree with that. The Fullerton officers never argued that there was a community caretaking exception that didn't require exigency. We're not arguing that here. It was made very clear at the hearing at the MSJ at ER 44, that position. The emergency aid exception merely stems from an officer's community caretaking function rather than his investigatory function, but it's unquestionable that there must be objective indicia of an emergency, danger, or need for medical attention.
Excuse me. So sure. In this case, if we could get to it, because your time is ticking away, and it's an important case. So what's the objective indicia of an emergency, please?
So here,
my understanding is that the call was made by Mr. Toman, the younger, right?
Correct.
On the business line, not the 911 call.
Correct.
Right? And asked for somebody to check on his dad. He hadn't heard for his dad in a week.
Correct.
All right. So it seems like the most comparable case we have Martin. I think you rely on Martin. And that's a case where a father, very similar, father called, expressed urgency, really thought his daughter was in trouble. The same thing was true in Cervantes. In both of those cases, we talked about the need for emergency, right?
Right.
They had an urgent call. They went there, they knocked on the door, they got no response. In both of those cases, no response. In one case, they thought a crime might be afoot. And in the other case, they had indication she was in there, she wasn't answering the door. Right. And we agreed in those cases there was reasonable basis to suspect an emergency. But in this case, there's a call to the business line, not 911. I don't see any expression of emergency from the son. And I think very importantly, when the officers showed up at the home and knocked on the door, they got answers. There were people inside talking with them. So I just want you to know where I'm coming from so I don't use up too much of your time. But tell me why there was objectively a reasonable basis for concern about an emergency.
I think here the concern grew as they knocked on the door and they got a response that he's in there, but we're not going to let you see him or talk to him.
Did they say that? I can hear on the video, I can hear them saying, do you have a warrant? But did they say the words you just said?
No, she just kept saying, I'm going to talk to my attorney. Do you have a warrant? Do you have a warrant?
So she can do that, right? She can ask for a warrant.
Well, excuse me?
She can ask for a warrant, or are you saying that's criminal conduct?
No, that is not criminal conduct.
Okay.
What we're saying is that, so the only case that the court cited on the second prong to deny qualified immunity was Calabretta. And in that case, there was no urgency like you're describing. The children were seen at the door and they're known that weren't being abused. Here, unlike that situation and more like the Martin cases where there was a concern, we had a reporting party was a close relative, unlike Calabretta. Unlike Calabretta, the son had been interviewed, whereas in Calabretta, the reporting party had not been interviewed. He was even interviewed while the officers were on the threshold.
Did he say anything that indicated there was an emergency? That's what I'm trying to get at. What's the emergency?
He said that his father was 92 years old. His organs were failing. He had multiple health ailments. He hadn't heard from him.
But he wasn't alone, and he had a care provider.
Right. Well, the care provider that the officers were aware of, they were given the care provider's phone number. And it can be heard on Crabtree's BWC. They called the care provider and it went quote, straight to voicemail.
Okay, can you tell me, sorry, which, there's a lot of different video clips. Which one is that? You just told me the officers.
It's Corporal Crabtree's BWC.
Thank you.
Okay. I believe it's A, but I don't have that in front of me.
So you said after the officers arrived, you think it escalated to an emergency. Can you tell me?
So they already had all of that information, that he was ailing, that he was elderly. The caretaker that the son knew of was not answering the phone. They spoke to the apartment manager who said that, very alarmingly, he had been visited by a priest within the last couple days. So all of those things kind of are combining to the circumstances that are making this pretty clear that there is an elderly man who might be in dire need of medical care behind that door, that nobody is providing any information about him. The woman doesn't identify herself as his wife, his caregiver, or any of that. She just says, I'm calling my lawyer. Do you have a warrant?
But the problem I have is that none of that would have changed in the 2 hours that it took them to get a warrant, though it seems, at least questionable that they had probable cause for a warrant. But is Martin your best case? Is there any case that's more helpful to you than Martin?
Well, I think our point is more on that second prong. You have to have clearly established law. You have to have a case saying that we cannot do this, and there isn't one. The court only cited to that Calabretta case, which is radically factually dissimilar to the facts of this case.
Right, but here I think what Judge Kristen's questions were getting at is that there was no evidence of an exigency at all. And that seems to be at least a reasonable way of looking at these facts. So Martin, the only evidence of an exigency was that the father said that the daughter was in trouble and it was of some matter of urgency. But here there was nothing. I understand the points you're putting, but there's nothing that would have changed in the 2 hours that it would take to get a warrant. So that's why I'm looking for what's the best case that they could have relied on to say there was an exigency.
Well, I think all of the no answer cases where they go to the door and they don't receive an answer, I think this was just as good as no answer because they didn't have an answer from Mr. Tuman himself. They had an answer from someone who didn't identify herself, who wasn't his caregiver as far as the officers knew, and who didn't provide any information about him. So the Martin case, even the
they didn't ask forgive me, but I don't think, and I want to make sure since there's several different body cams, I don't hear anyone asking for her for information, just saying she's requesting a warrant and they're continuing to say, we don't need a warrant, open up, we're going to kick the door down, you're going to be arrested. But did I miss it? Did they ask for information?
They do. They specifically, they ask, is he there? And then they say, we need to talk to him.
Can you tell me which body cam is that?
That is Crabtree's again, and then it's also McShane's in part, because McShane is the officer who went around to the back, saw the two men who saw him, said they lived there, and then kind of went in and shut the blinds.
So McShane, okay, I listened to McShane. I'll go back and re-listen to Crabtree. I don't want
Crabtree is the main officer who was at the door speaking to Mrs. Tuman for the vast majority of the time.
Oh, well, then I have heard that. Okay, all right.
So getting back to the no answer cases, the reason that
you think it's more you think it's more concerning that there was an answer here than the cases where there wasn't an answer? Is that your position?
No, my position is that it's just as alarming. Those cases that they talk about and that the justices talk about in Kuhnle and their concurring opinions, where there's an elderly person who's at home and nobody answers the door, and Justice Kavanaugh said, well, of course that's a time that we can enter. I don't see this as any different. And in fact, it's somewhat more alarming, the fact that someone is responding that is not his caretaker as far as the officers know.
Why would they presume that? These people, why would they presume that the occupants aren't exactly that?
Because Mr. Tuman was not on that lease in terms of being an occupant. That was verified before they knocked on the door with the property manager. And also the son had given them a caretaker's phone number who was not answering the phone. And so it's, I think, a reasonable assumption that the woman answering the door is not the person who was not answering that phone. No, apparently the son did not know that his father was married to this woman. The most that the officers knew and that the son knew was that she had been a friend prior to that. So a lot of questions were raised by, who are these people? There's 3 people in an apartment with an elderly man whose organs are failing, who's being visited by a priest a couple days ago.
Did they ask? I mean, that's just consistent with end of life. I mean,
well, I mean, that's kind of the point, and that's the concern. That's definitely the concern. I mean, is he in need of medical danger?
Could I bring you to a different issue, which is the arrest under California Penal Code Section 148. So we have a case that says, Prescott saying that there's a constitutional rule that citizens have a constitutional right to withhold consent to a warrantless search, and therefore no arrest could be based on refusing entry when the officers had no search warrant. So does that case resolve this issue and say they had no basis for arrest under Section 148?
Are you talking about the Wetzel case that was?
No, I'm talking about a case called Prescott, which held that this was a case where a woman did not allow the officers into her apartment, even though the officers were pretty sure she was harboring a fugitive. And they arrested her for harboring a fugitive, and the court said her refusal to let the officers enter her apartment could not be the basis of the criminal charge against her.
Right, and I'm not familiar with that case, but the facts seem almost on point with the case that was briefed very extensively, Wetzel, where the woman refused consent to enter in a hot pursuit. And the court made it very clear, and I think it holds true in any case of this sort, that it's not the refusal of consent that's the problem. In that case specifically, the court noted that at no time the officers told the woman that they were going to make entry into the house. It was that refusal to allow them entry, not the consent without knowing that they were about to be obstructing a lawful entry. The same is true here. When she's saying, I want a warrant, she's not guilty of 148 yet. When they say, we have authority to enter this house, we're going to enter this house, we're going to kick down the door unless you allow us to enter that house, that's when the 148 starts.
Was that the police say they have authority, and that's authority, right? Whether they have it or not?
Well, they did. They did have authority under the emergency aid exception.
If there's emergency aid, right?
Yes.
Yeah.
I mean, I think, again, the very important point is whether or not that was clearly established. In this Kuhnle case, you have 2 Supreme Court justices arguing about whether or not checking on an elderly person is something you can do without a warrant. One agrees, one says resoundingly yes, one says maybe we haven't answered it.
And and the big difference, right, in that case is that there's an elderly person and no answer at the door, and we don't know if that person inside needs help. Here, there was an answer.
There was an answer, but not by the person, not by the elderly man. There was no ability to confirm whether or not that man was safe inside, whether or not there was a dead body inside, which is another case that was cited in the briefs.
Want to save some time for rebuttal? You're down to 54 seconds.
That's, I'll submit, thank you.
And we'll hear from the other side.
Good morning, and may it please the court. There is no welfare check exception to the Fourth Amendment.
Did you identify yourself?
I'm sorry, Morgan Ricketts for the appellees.
I'm having a little hard time hearing you. If you could keep your voice up, that would help me.
And adjust the microphones, please. Thank you.
Thank you. Pardon me.
I think the opposing counsel's conceded there's no emergency care. What she needs is an emergency, right? Not a caretaking exception. So
Correct.
I think she's conceded that point.
And so under Roberta, the appellants must show there was an emergency at hand. They had to have an objectively reasonable basis. Under Martin, under Michigan versus Fisher, Brigham City versus Stewart, every case to consider this has said there's got to be a reasonable basis to conclude there's an emergency.
So as I understand opposing counsel's argument, she says there's no case that shows that this was not a objective basis for a exigency, in that the officers had received this call and they didn't know if this person was being abused in the house, and the person in the house refused to let them see him. Why? So it wasn't clearly established that what they did was in violation of our law, or there wasn't an exigency. What's your response to that?
My response is that Sandoval versus Las Vegas, which is this court's decision, held that simply invoking the unknown in these circumstances is not sufficient to enter without a warrant. If the officers do not have the objectively reasonable basis, if they're not sure there's an emergency, under Hopkins versus Bonvicino, another case by this court, they must take additional steps to investigate and verify whether there is an emergency in the first place. That's what the officers were doing. They were investigating for 31 minutes, but they never received facts that would suggest there was an emergency. They received facts to suggest this person was chronically ill, terminally ill, receiving medical care regularly from mandated reporters, but they never received any information that anything in the past week was urgent or emergent.
They never got to talk to the 92-year-old, did they?
Well, not until they broke down the door, no.
Say again?
Not until they broke down the door.
Oh, yeah, right.
And somebody on hospice who's 92 with a lot of health issues, there may be very good reasons that they're not coming to the door.
They might be bedridden.
They may, and yes.
If they're in a position where they're calling for a priest, one might think they're bedridden.
Correct. And, that's another thing about hospice. Often they come because somebody's bedridden.
So is it your position that there either was an emergency or there wasn't? As to the entry, I think we get that. What about the arrest? What about the 148?
Well, the officers should have known before they broke in that under People versus Wetzel, state Supreme Court case in 1970, they had no right to arrest somebody for refusing to allow entry. Even if they had an emergency aid exception that applied, the occupants are not expected to know that. They are able to refuse consent. And in People versus Wetzel, the person actually stood in the door and barred the officers from coming in with her body. The Supreme Court in California said that can never be a public offense, a crime.
So that's a question of state law, right? And we're looking at whether under the Fourth Amendment, so we're looking at federal law for a 1983 action.
Yes.
So People v. Wetzel, we know that under California law, you can't arrest someone for a violation of 148 unless the police are acting lawfully. But that doesn't tell us about what's clearly established for purposes of Section 1983. So what's your best case for under 1983 under federal law?
Of course, Your Honor, that would be United States versus Prescott. And in addition, there is a Ninth Circuit case from 2004, Wall versus County of Orange, that says state law requirements are relevant in assessing the reasonableness of an arrest. That's a quote. I can give the citation. That's 364 F3D 1107.
Hold on, 364 F3rd what?
1107.
Thank you. What about the excessive force claim? Unreasonable force?
So the district court,
in the arrest itself?
In the arrest itself. So the best cases would be Meredith versus Erith, I think it's pronounced, Ninth Circuit, and Blankenhorn versus City of Orange. So in Blankenhorn, we had a known gang member who was obviously trespassing in a place that the officers had personal knowledge he was not allowed to be. He had been banned from the mall, the block at Orange.
So those facts, I know the district court relied primarily on Blankenhorn, but those facts are not very close to this one. So is there a case which has facts that are closer to this one?
I think the facts are very close in Blankenhorn, but I think Meredith versus
Blankenhorn was refusing entry under a welfare check theory.
It didn't involve entry in a home. It struck me as pretty disparate. What about Meredith?
The Meredith versus Arith involved, I believe, federal agents investigating tax crimes, and they entered a place that was someone's home, and they were seeking to gather evidence. This person was somewhat disruptive, loudly demanded a warrant, and made no attempt to flee, was not fighting with the officers, did not present a threat. The Ninth Circuit held that slamming her to the ground or throwing her to the ground and handcuffing her was an excessive force. I just want to point out that from the moment the officers knocked and found that there was an answer, there were able-bodied adults in the apartment with Mr. Toman. They were authorized to be on the lease. Every fact that they learned from there on simply dispelled any concern that they might have had. There were multiple healthcare workers that had come over the past week since Kevin Toman had last heard from his father. Did the
officers know that? Did they learn that from the
They learned that from the apartment management.
And that's the woman at the front desk in the video.
Correct.
Yeah, okay.
And her assistants. There were three apartment employees. They also learned he'd been visited by a priest and a detective. So all of these people are not affiliated with each other. They're disinterested, mandated reporters.
Excuse me, can I ask, forgive me for interrupting. The other police department, I think there's the Fullerton and it was Brea, I think police were checking on the son's concern about financial elder abuse. Did the officers know that before they kicked in the door? Did they learn that from the managers?
Yes, and I do want to point out that, well, actually, let me just go back to one correction I need to make. Earlier in the opposing counsel's argument, there was a mistake. Crabtree is the one that's investigating. McShane is the one at the door speaking to Mrs. Toman.
And who kicks in the door, McShane?
McShane.
Yeah, okay.
Okay, so when Crabtree, who's investigating, speaks to the apartment managers, they inform him, yes, the elder abuse financial detective came by the other day. He does not react to this. He says, okay, cool. He doesn't ask any further questions except about who's on the lease. He never reports that to me.
Who was he told is on the lease?
Lourdes Toman. He didn't know her last name, but he was told Lourdes was on the lease.
Okay.
He's also told that there's a paper that says James from the hospice. He doesn't ask to see that. He shows no interest in anything relating to medical diagnosis, medical care, medical emergency. He doesn't report most of this stuff to McShane. And then McShane and Crabtree fail to report anything relating to a medical emergency, medical condition, medical diagnosis, caregivers coming, hospice, bandages. Any of these facts that the appellants are now relying on to create this emergency were not reported to Sergeant McCaskill, the responding supervisor. When he arrived, they simply informed him, we've been able to confirm that James lives here, it seems, and these people are refusing. They're not letting us in. Sergeant McCaskill responds, and this is at minute 34:30 of Exhibit 1, McShane's body-worn camera. He says, so what I got from what you're both telling me is he lives here, he's in his 90s, we have to check the welfare, and we're not being allowed in to check the welfare. And that's the entire analysis that Sergeant McCaskill engages in before authorizing this entry. Shortly before they break into the door, the occupants ask, do you have a warrant? And the officers respond, we don't need a warrant, we're doing a welfare check. As soon as they break down the door and get Mrs. Toman into the hallway, she looks at Sergeant McCaskill and says, you don't have a warrant? And he responds, ma'am, we don't need a warrant to come inside your house and check the welfare of somebody. There's no question in the record that the reason they entered was because they purely misunderstood the law in this circuit. They did not respect the bright line rule that this court laid out in Calabretta, which is very similar. We had a report actually of suspected abuse of a child. There was reports that a child was screaming, that they were yelling, no, daddy, no. And when the social worker went to try to conduct this welfare check, the occupants objected. The court said, that's not exigency, that's not an emergency. You need to go get a warrant. If there are no further questions,
All right, thank you.
Thank you.
Thank you. You have a few seconds left for rebuttal.
All right, just very quickly, I wanted to point out a couple cases. First, when it comes to these kind of cases, we have to look at the objective reasonableness. The officer's subjective intent, which counsel was kind of going into, is not controlling here. Also, Blankenhorn is the only case the court cited to deny qualified immunity on the use of force, and it's radically dissimilar. The uses of force found unreasonable were hobbling, a gang tackle, and punches to the face, none of which happened here, so it can't possibly...
What about the obviousness exception? What about there are those rare cases where it's just so obvious?
Well, I think that's definitely not the case here when we have such a minimal use of force. They took her, she struggled with them, fought with them, they took her to the ground and handcuffed her. There was no mace, there was no OC spray, there was no baton, there was no hobble.
There's injury. She suffered injuries. She was no match for those officers. They took her down. There's a knee on her neck. There's a spinal injury.
And I mean, I don't have the site in front of me and I don't have time to look it up, but there's cases saying that just because an injury occurred doesn't mean that the force is necessarily unreasonable.
But we have the video and you're describing this as minimal use of force. Is that your position?
Oh, absolutely.
All right.
And one more case I wanted to point out is White v. Pierce County. That case is where we had a report of child abuse. They did answer the door, like your honors are saying happened here. Somebody answered. But the report was to a child's back, and the dad said, no, you can't see his back. I think this case is very akin to that case where entry was permitted because the person that we needed to see was not the person who was answering, and it was definitely not the person who opened the door because somebody else was kind of blocking the police from doing that. And that's it. Thank you, your honors.
Okay, thank you. The case of Lourdes Toman versus Davis Crabtree is submitted.